Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel, Bid Protests.
All right. Hey, everybody. My name is Kaylee Scalzo. I'm a partner at Covington here in DC. I know you all were expecting to see my partner, Jay Carey. Lucky you get me instead. He sends his regrets for not being able to be here. So I can think of no better way to kick off these couple days of programming than to talk about bid protests, which are objectively and without question the best and most interesting topic in all of government contracts, according to me. So I will keep these introductory remarks short because we've got a lot to cover in a short amount of time. But what we're going to do today is cover some of the most notable developments among bid protest cases over the past year, focusing on cases that either changed law or practice in some way or left open significant questions for the future. Before I launch into the first case, I'm just going to introduce my fellow panelists here who are going to lead the discussion. We've got Craig Holman, a partner at Arnold & Porter, Adam Lasky, a partner at Seyfarth Shaw, Dawn Stern, a partner at DLA Piper, and Dan Graham, a partner at McDermott, Will & Emery. Okay. Oh, there's me. All right, our first case we've got up is Percipient AI versus the United States. This was at the Court of Federal Claims under case number 2328C and is now pending on appeal at the Federal Circuit under case number 231970. I really hope that the Federal Circuit didn't issue a decision this morning because that's going to totally mess up my remarks, but here we go. So this case has everything. It has DoD's preference for commercial products. It has questions of whether or not a protest challenges matters of contract administration. It has interested party standing. It also has blue and gold. I'm not even going to have time to get into the blue and gold stuff. I'm going to do the best I can to lay all of this out in my allotted time. Jay has given me a tall order here, but hopefully we'll have the appeal resolved by the end of this. Let's begin with just some baseline facts here. This case involves a procurement by the National Geospatial Intelligence Agency going by the name of Sapphire. It's an IDIQ for, going to grossly oversimplify, certain technology relating to the storage, dissemination, and analysis of geospatial intelligence. NGA awards the IDIQ to CACI along with several task orders, including, as relevant here, Task Order 1, which includes computer vision software. You don't want me to try to explain that, so all we really need to do is remember the phrase computer vision. Meanwhile, the protester here, Percipient, has a commercial computer vision product that is known as Mirage, which, according to Percipient, can meet the computer vision requirements under Sapphire. Percipient didn't bid on Sapphire, however, because it isn't able or wasn't able to meet all of the Sapphire requirements, only the computer vision stuff. And so what it did instead was reach out to CACI and to NGA and advocate the use of Mirage during Sapphire performance. Let's fast forward to the part where Percipient learns that CACI is not, in fact, going to use Mirage as part of Sapphire performance, at which point Percipient files its complaint at the Court of Federal Claims, raising the claims that you see on the screen here, which I'm going to broadly characterize as allegations that NGA violated its obligation to use commercial products to the maximum extent practicable. So thoughts are swirling in your head at this point. You're thinking back to that list of issues that I rattled off at the beginning. For purposes of actually talking about them, I'm going to divide them into two broad categories. On the one hand, the commercial product preference issues, which is the actual substance of Percipient's complaint. And then on the other hand, all of the jurisdiction and justiciability issues that, between you and me, I think are actually more exciting and interesting to talk about, and are the ones that are relevant on appeal. But because Jay made 3 slides on the commercial product stuff, so I don't get in trouble, we're going to talk about that first. Okay, as a matter of statute, DoD is required to put forth certain effort and consideration into using commercial products and non-developmental items for purposes of Percipient. That kind of breaks down into 2 categories of obligations. On the one hand, an obligation to use commercial products to the maximum extent practicable, and to kind of roughly speaking, impose that requirement on contractors as well. And then second, to conduct market research necessary to determine whether or not there are commercial products that would meet the agency's needs, and again, to kind of roughly impose that same obligation on contractors. This is not the first time that this statute has come before the Court of Federal Claims. There was a sustain on this issue in 2016 in the Palantir case that was affirmed by the Federal Circuit. Some of the relevant language is up on the screen here. Basically, the court there found that there was no evidence in the record that the agency had used the results of the market research to determine whether there were commercial products available. In Percipient, however, the Court of Federal Claims doesn't even get to this issue of the commercial product preference, and instead dismisses the case for lack of jurisdiction because it finds that the protest is in connection with the issuance of a task order and thus barred by the Federal Acquisition Streamlining Act task order bar. So the court addresses that particular issue in an opinion that's relatively brief. You can see some of the key language up on the screen there. Just for the sake of time, I'm not going to read all of it, but you've got it in your materials. We're going to be in suspense on this issue until we hear from the Federal Circuit, because that's the issue kind of squarely presented to the court. Like I said at the outset, case is fully briefed. It was argued in November, so at this point, we're just waiting. To give a really quick preview, though, of what Percipient argued on appeal, the main argument, in my view at least, is that Percipient is saying the FAFSA task order bar prohibits protests in connection with the issuance or proposed issuance of a task order, and not all protests in connection with a task order. So they're really focused on the words issuance or proposed issuance in the statute. They point out that the action that they're challenging here actually postdates the issuance of the task order. It relates to kind of how the task order is being conducted. And as evidence of that, they say, hey, we're not even seeking rescission of the task order as a remedy. This case and this issue would be interesting kind of regardless of the broader context, but it's especially interesting in the context of these recent Federal Circuit decisions that have been chipping away at jurisdictional rules and taking a, I guess I would say, more flexible approach to certain procedural bars. So there's the natural question of whether or not the Federal Circuit's going to take a similarly flexible approach in interpreting the FAFSA task order bar here. As I mentioned earlier, though, this is not the only interesting procedural question in this case. We've also got the issues of contract administration and interested party standing. The Court of Federal Claims actually ruled on both of those issues in an earlier opinion that was subsequently vacated and replaced by the opinion that addresses the FAFSA task order bar. The Court of Federal Claims found in Percipient's favor on both of those issues. So those issues aren't presented kind of directly in the appeal, I'm assuming because that opinion was vacated and because those issues were decided in favor of the appellant here. But the government, in its brief, actually presented these other procedural issues as alternative grounds for affirmance to the Federal Circuit. Whether or not the Federal Circuit kind of takes up that offer, we'll see when the decision comes out. But even if the Federal Circuit reverses and remands on the task order issue, I would think there's a pretty strong likelihood that these other procedural issues will resurface in one form or another if and when the case is back at the Court of Federal Claims. So just to briefly touch on these two other issues, first we've got the question of contract administration. It's well established that you can't protest a matter of contract administration. I think all of us, when we kind of think about that in practical terms, generally view that as meaning you can't protest something that happens after the award of a contract and during performance. You know, again, there are exceptions and that's oversimplifying, but generally speaking, I think that's how we tend to think about it. And that's one of the arguments that the defendants in Percipient made. They said, hey, what Percipient's actually challenging is the way that CACI is performing, the way that the agency is supervising performance, and that is contract administration. The complication, though, is that ends up running kind of headfirst into Tucker Act jurisdiction and how procurement is defined in that in connection with prong of Tucker Act jurisdiction. What the Court of Federal Claims ended up concluding on this issue is that because Percipient was alleging or is alleging the violation of a procurement statute, that means that there is Tucker Act jurisdiction because they are alleging a violation of law in connection with a procurement. I think that leaves open, though, the question, at least in my mind, of kind of where contract administration ends and where bid protest jurisdiction begins. So again, we'll see if the Federal Circuit ends up getting to that issue. And then the second is interested party standing. I think we can probably all say it together. We have this like so drilled into our brain. To bring a bid protest, you have to be an interested party, and to be an interested party, you have to be an actual or prospective offeror with a direct economic interest. What we generally think of that as meaning is that you have to be a prime offeror, and a prime offeror who, but for the agency's error, has a substantial chance of getting the contract award. Here, though, there's no dispute. Percipient did not submit a proposal. It did not want to submit a proposal. So it's kind of more like a subcontractor or a vendor. The Court of Federal Claims, though, in the vacated decision, found that Percipient did have standing because Percipient offered Mirage to NGA in the colloquial sense of offering, and that because what Percipient wanted was its product being incorporated into the contract, that created a direct economic interest. So again, we'll kind of see how that comes out at the Federal Circuit, if at all. So just a couple kind of concluding comments about this. It strikes me that one of the things kind of nagging around these procedural issues is this question of if this bid protest wasn't the right way for Percipient to vindicate its interests, what was it supposed to have done instead? And maybe that came up at oral argument, but there's kind of like this awkward situation where everybody knows this isn't a normal bid protest, everybody knows it doesn't fit into the normal procedural boxes of a bid protest, but nobody can really articulate what Percipient should have done instead of this. That being said, we all know that there is not a legal remedy for every wrong, and that's especially true when you're dealing with a defendant who has sovereign immunity. So maybe the answer from the defendant's perspective is just, sorry, there is no cause of action here, bid protest or otherwise. But particularly if the Federal Circuit is trending away from rigid procedural bars, that may make the affirmance of a dismissal a tougher sell if the court and the defendants can't point to this other thing and say Percipient should have done X instead of doing Y. Now, on the other hand, we've got this huge line drawing question of whether or not letting this case to proceed would open up the floodgates, and all of a sudden subcontractors and vendors are filing bid protests, not only at the award phase but during performance. Selfishly, as a bid protest lawyer, I'm all in favor of that, but from the perspective of the orderly functioning of the procurement system, there are some serious questions about how that would work. And I think the defendants point this out in their briefing at the Federal Circuit, but if the entire reason for the FAFSA task order bar is to make task order procurements more streamlined and easier, one would think that this would have the kind of opposite result if subcontractors or vendors are allowed to pursue protests. So keep an eye out for the Federal Circuit decision. I'm sure there will be a lot to talk about when it comes out, and that's all we've got for now.
Good morning, Government Contracts Procurement Bar. It's fantastic to see so many of us all in the same room again. Let me start out today by saying thank you to PubK for putting on this extraordinary event and bringing this all together, bringing us all together, really. I want to speak today about a topic more so than a particular case. In fact, I think this topic is so important that I'm going to try and touch on 6 different cases very quickly from the U.S. Court of Federal Claims in 2023. And the topic I want to talk about today is corrective action at the U.S. Court of Federal Claims and how it occurs. So, as members of the Procurement Bar, we all know that corrective action has been around for a long time. We also all know that it happens in a material percentage of cases. So why did I think 2023 was a different year for corrective action at the U.S. Court of Federal Claims? I want to say that I think it actually started a little bit earlier, but back in 2020, not in a bid protest case, Judge Solemson wrote a decision, Keltner versus the United States, in which he raised the topic of when is it appropriate for the U.S. Court of Federal Claims to remand a matter to a government agency for corrective action. And before that decision, I would say that in the vast majority of procurement cases, everybody simply assumed that it was okay for remand, or many times it happened without question. What's happened since 2020, when Judge Solemson looked at the jurisprudence, not just in the Court of Federal Claims about remand of cases, but also more broadly in courts generally, has been an increase, in my opinion, in people questioning whether or not it's proper for the United States to remand actions. It also has resulted in people, I think, increasingly questioning whether or not it is appropriate for the U.S. Court of Federal Claims in response to government requests to dismiss actions as moot based on corrective action. And I'm going to show you just very quickly today 6 different cases that have come out of the U.S. Court of Federal Claims in 2023. I obviously can't talk about them all, and I'm going to try and just touch on them very quickly, but I want to alert folks to this issue and the type of litigation, this type of questions that are being asked regarding corrective action, because indeed it happens in a large percentage of cases that are certainly at the court and GAO, but we're going to talk about the court today. So it is important to all aspects of the procurement bar. So before I talk about corrective action, I have to very quickly touch on what the Court of Federal Claims can do in a bid protest by way of remedies, because that informs what protesters can ask for, it informs what the government can offer, and it informs what interveners should be concerned about. So the source of the court's power to issue relief in a bid protest derives from 28 U.S.C. 1491b2. That's the Tucker Act as amended. I'm going to read this. I promise I'm not going to read other stuff today, but I think this part, understanding the statute, is important for us. It says, to afford relief in such an action, that's a bid protest action, the courts may award any relief that the court considers proper, including declaratory and injunctive relief, except any monetary relief shall be limited to bid preparation and proposal costs. The court, in looking at this statute, has found that it has essentially 3 different types of non-monetary remedies that it can afford in a bid protest case. Injunctive relief, that is an order mandating or prohibiting particular conduct. Declaratory relief, where the court tells the parties or interprets and identifies the parties' legal rights and responsibilities, and remand with direction to either offer a fuller explanation or consider the matter afresh. If you want to read about these different types of relief, this is not a 2023 case, it's a 2022 case, but Judge Solemson and IAP Worldwide spent quite a bit of time discussing how these different remedies exist at the Court of Federal Claims and where they overlay with one another. But let's now drill down a little bit on what I want to talk about today, which is corrective action at the court. And when we do that, we've got to all have an agreement on what is corrective action. We've all experienced it, but the definition of what is corrective action, the active one, comes from the Federal Circuit in Federal and DeLucorp, and it is an agency action usually taken after a protest has been initiated to correct a perceived prior error in the procurement process, or in the absence of error, to act to improve the competitive process. Okay, how does corrective action happen at the court? Well, this is more anecdotal and looking at cases than dictated, but there are really 2 primary ways that the case law shows us that the United States takes corrective action at the U.S. Court of Federal Claims. Not only 2 ways, I'm going to show you in a minute, there are other ways that the United States has done so, but these are the 2 primary ways. So I'm going to talk about the tests related to these corrective action methods in a minute. The first is the United States sometimes will take corrective action by putting in a notice of corrective action and asking the court by remand motion to remand the matter back to the agency to reconsider some aspect of its decision. For those of us who need an idea of what a circumstance like that might be, a typical circumstance for this type of corrective action might be a protest where somebody alleges an organizational conflict of interest, and the United States, in connection with that protest, agrees that it has not done the analysis necessary and asks the court to remand the matter back to the agency so that it can perform the analysis. That's a corrective action that involves a remand request. A second type of corrective action that we do see frequently at the court is a broader corrective action notice, perhaps a cancellation of a solicitation in a pre-award procurement, or in a post-award procurement, the termination of award and an agreement to reevaluate, followed by the agency asking the court to dismiss the matter as moot because the protester has received the relief that it has requested, or the harm that is occurring to the protester is no longer happening. So these are the two types of corrective action. What we have to ask as protest lawyers now is, how do we measure whether the type of corrective action is appropriate for the circumstance? Can the court remand the matter? Can the court declare the matter moot? And that's where the action has been the last few years that I want to talk about today. I want to touch on Keltner one more time, just to give us a quick definition of what is this first approach, voluntary remand during a corrective action. Again, Keltner is not a bid protest case, but it started some of the voluntary remand cases that we're seeing at the course today. It is a motion for voluntary remand is a government request after a party has filed a complaint seeking judicial review of agency action, that the court send the challenge action back to the agency for further review or consideration. Very quickly, before I flip to the next slide, I mentioned these aren't the only types of corrective action. We saw very interestingly in 2023, an agency took corrective action in a bid protest matter without either asking the court for a remand or asking the court to dismiss the matter as moot. The agency simply took corrective action during the bid protest of its own volition. That's a case Synerin. I'm not going to talk about that case at any great length today. Judge Meyer's decision, fascinating read. It's on appeal. May make interesting reading from the Federal Circuit someday. And it is a case involving multiple parties, so probably numerous counsel in the room today were involved, including me. When we talk about whether it's proper for the U.S. Court of Federal Claims to remand a matter to an agency at the government's request, we need to know what the test is that the court will apply. The test that the court is applying today, drawn from a non-procurement case, SKF, international trade case issued by the Federal Circuit back in 2001, is the substantial and legitimate test. What the court asks when it is faced with a remand request by an agency, if that remand request is challenged by one of the parties, is whether the agency's concern driving the remand request is substantial and legitimate. If the remand request is substantial and legitimate, remand is appropriate. So how do we know whether a remand request is substantial and legitimate? That itself has a three-part test that we see drawn out in the Piedmont Propulsion decision issued by the U.S. Court of Federal Claims in 2023. That's a Judge Sommers decision. It's about 4 pages long. It's a quick read if you want to see how remand works in the corrective action process at the U.S. Court of Federal Claims. But Judge Sommers, drawing from both Keltner and SKF, noted that there's a three-part test to determining whether the agency's or the government's request is substantial and legitimate. Is there a compelling justification for the remand request? Does the need for finality in the bid protest outweigh the justification for voluntary remand? And is the scope of the agency's remand request appropriate? If these 3 points are there, the remand request is appropriate. Piedmont Propulsion is a 2023 case that I mentioned where the court refused to remand the case despite the government's request. It was an OCI issue, and it was one of 8 counts that was pending in front of the court. So I'm not going to go through this slide right now because we're going to be a little bit tight on time, I can see. But in your materials, you're going to see 4 common reasons for denying remand. So if you're facing a remand request for an agency and you're looking for ways or reasons you might challenge or want to challenge that remand, you can look back to this slide in some of these cases. So the second type of corrective action that we're seeing frequently at the court, and we're now seeing in 2023 get challenged, I think, increasingly, is corrective action where the agency takes broad corrective action and one of the parties challenge and asks for the agency asks for the court to dismiss the matter as moot, and one of the parties challenges that corrective action. So in this circumstance, where an agency is taking corrective action and asking the court to dismiss as moot, the government bears the burden of establishing the protest as moot. This test is drawn out in the Secretary case I have cited here, which is a Judge Hertlinger case from 2023. Very interesting read on mootness, in which the court rejected the request of the government to dismiss the matter as moot. The court found the matter was not moot, despite what the government, or certain counts of the matter were not moot, despite what the government believed were broad corrective action points. Another case from 2020 that I have mentioned here is Bitscopic. That's a Judge Rommel decision in which the court found 2 counts of a complaint were indeed moot based on a solicitation cancellation. So if you're looking for recent mootness cases, those are both good cases to see. Very quickly, what is a moot case? What moots a case, or how do we determine whether a case is moot? From the Secretary decision, I'm going to focus on 2 points. There is no reasonable expectation that the alleged violation will occur, and interim relief or events have completely and irrevocably eradicated the effects of the alleged violation. If those 2 points are present, the matter is moot. So one other interesting case that I'm not going to have time to talk on in any detail today from 2023 is ExcelGov, another case in which the United States moved to dismiss a matter as moot based on corrective action. In the Court of Federal Claims, Judge Solemson in that decision refused to dismiss the matter as moot as ExcelGov. What's interesting about the ExcelGov decision is Judge Solemson noted that the agency needed to better document its rationale for remanding the case. One last quick note on corrective action for the practitioners out there to be careful about. One of the things we're seeing at the Court of Federal Claims now is that folks, interveners, who just simply participate in or acknowledge the corrective action without objecting are being found to have, in some circumstances, waived their ability to raise arguments at a later date. Defense Integrated Solutions, a Judge Solemson case from 2023, found DIS, the intervener, had waived its challenge by consenting to the government's voluntary remand. So if you're an intervener, be careful on that front. I thank you for your time today, folks.
Thanks, Greg. So, let's see, the slides going. So in one of the last bid process decisions of 2023, we saw the Court of Federal Claims issue a decision in Global Canine versus U.S., where the court granted a permanent injunction disqualifying one of the awardees from the procurement due to a material misrepresentation in its proposal. The Global Canine decision raises 2 particularly interesting questions. First, it reflects a continuing and potentially widening divergence between GAO and the various judges of the court on the role that the intentionality and intent to deceive plays in a material misrepresentation case. And while it doesn't require a blue moon nowadays to see disagreement between GAO and the court, this might be one of the areas with the widest divergence between the judges of the court themselves. The second issue that's interesting, I think, is that the decision is not only a reminder of the importance of intervention, but also raises questions as to whether there may actually be situations where an awardee is not merely an interested party, but is an indispensable party for adjudication of bid protests under the court's Rule 19A. So Global Canine involved a U.S. Postal Service procurement for third-party canine mail screening. And that contract is basically what it sounds like. Essentially, the contractor uses dogs to screen for explosives in U.S. mail packages set to be transported on passenger aircraft. And when a dog alerts to a potential explosive, the package then undergoes some sort of secondary screening, like X-ray analysis. The slide shows some photos of contract performance. And in the spirit of presentation on material misrepresentation, these certainly are real photos of contract performance and not AI-generated images of what I dream contract performance might look like. So the decision we're going to talk about is actually a decision involving the Postal Service's third attempt to award these contracts after the first two award decisions were nullified by bid protests, predominantly on OCI grounds. So on his third try, the Postal Service split the contract awards between two companies, K2 and AM Canine. As will be relevant to our discussion of material misrep, the agency rated K2 good on the past performance factor based on K2's representations regarding the scope and quality of performance of where it was a subcontractor to Global Canine, who happens to be the protester in this case. So Global Canine protested the contract award to K2, with its principal argument ultimately being that the award was tainted by material misrepresentation in K2's proposal. Now, unfortunately, it wasn't a material misrepresentation regarding the availability of key dogs, or whether the dogs were cats, but rather regarding the quality and scope of K2's performance as a subcontractor to Global Canine. To support these allegations, Global Canine supplemented the record with a declaration from its CEO concerning the subcontract and intended to contradict K2's representations. So before going any further on Global Canine, I think it's important to circle back and look at the variation in the role intentionality and intent to deceive have played in the various standards formulated by GAO and the various judges of the court for material misrepresentation prior to Global Canine. So let's start with GAO's test as the baseline. GAO splits the merits of material misrep, and GAO has actually been very consistent in this. So GAO splits the merits of material misrep into two elements. Falsity, the record must show that the representation in the proposal is false, and materiality. Misrepresentation is material where the agency relied upon it and it likely had a significant impact upon the evaluation. GAO does not consider whether misrepresentation was intentional in adjudicating materiality. The material misrep must also have been prejudicial, like any other protest. And if a prejudicial material misrep is found, GAO will consider whether recommending exclusion of the awardee's proposal from the procurement is the appropriate remedy, rather than merely a reevaluation. And while there arguably was some inconsistency on this element, the exclusion piece by GAO over the years, in more recent years, GAO has clarified that while degree of intentionality or negligence in making the misrepresentation may be considered in determining the appropriate remedy, intentionality is not a prerequisite to recommending exclusion of the offending offeror. So now shifting over to the court's test for material misrepresentation before Global Canine. While the court doesn't diverge from GAO on the falsity and prejudice standards, it does diverge on materiality and remedy. With respect to materiality, the judges of the court all seem to agree with GAO that the protester must at least show that the agency relied on the false statement in making its award decision. But then they diverge from GAO and one another on the role that intent plays in materiality. Pre-Global Canine, there appeared to be three different views taken by the various judges on the role of intent. View one, or what I'll call view one, has been that while intentionality is required, a misrepresentation is intentional simply by the fact that the offeror knew or should have known that the statement was false at the time made. In other words, intent doesn't require evidence of some intent to deceive or sinister motive. View 1 appears to represent the middle ground and what I would say is the majority view seen in most of the court's decisions. View 2, or what I'm calling View 2, is also intentionality is required, but further interprets intentionality as requiring an intent to deceive, some sort of sinister purpose, willful, egregious. This view obviously represents the strictest side of the spectrum. And then there's View 3, which is very far off from View 2, in that intentionality is irrelevant to materiality altogether. In fact, there was a case from a couple years ago where one of the judges refused to allow supplementation of the administrative record because the judge said intentionality is not relevant to this issue at all. This view represents the other far end of the spectrum. With respect to exclusion as a remedy, unlike GEO, most of the court's decisions have suggested exclusion is automatic in the face of a prejudicial material misrep, though there is at least one decision that raises some questions on that as well. So, moving back to the case itself, the court looked at material representation first on falsity. So starting with falsity, the court compared the statements in K2's proposal regarding its past performance as a subcontractor to Global Canine against the counter assertions and evidence in the protester's declaration regarding K2's performance on that subcontract. The court focused primarily on assertions in K2's proposal regarding its quantity and quality of its performance, and found that in each respect, the protester's declaration contradicted the assertions in K2's proposal, and the declaration was unrebutted. Therefore, the falsity prong was satisfied. And I think at this point it's worth noting that in most material misrepresentation cases, at the court at least, this protest ground is lost on the falsity prong. The falsity prong is often difficult for protesters because proposal statements are often mushy, subjective, and open to differing interpretations, so that the awardee, who is an intervener, can demonstrate how the statement could potentially be read and maybe it was intended to be read in a manner where it is not actually or provably false. But here the awardee didn't intervene. To make matters even worse, the alleged falsity involved the scope and quality performance of a subcontract between the protester and the awardee. So without the awardee, the government likely didn't have personnel knowledge sufficient to refute the statements in the protester's declaration. So a result of this confluence of unusual circumstances, the falsity prong went from being the most difficult element for the protesters to establish to being essentially the easiest element for the protester to establish, by the protester being able to present evidence that no one else in the case had really personal knowledge to refute. So next, let's look at how the court examined materiality in what appears now to be a fourth view on that standard by the court. So first, the court appears to have split the reliance part of materiality into a separate element, though frankly that doesn't really have any ultimate impact on the overall test, just kind of the order of the test was a little bit different, I think, in this decision. But second, with respect to intent as an element, the court at first appeared to adopt view 2, that intentionality is required and intent requires some willful intent to deceive. But after first shifting to the strictest end of the spectrum, the court put what appears to be a new view on view 2, setting a very low bar for protesters to demonstrate an intent to deceive via circumstantial evidence. And it's not new that you can use circumstantial evidence to support your case in material misrepresentation. I think that's pretty uniformly agreed to by the judges, but how the standard that was kind of used here was a bit new. So essentially the court held that if a false proposal statement was made in direct relation to solicitation requirement, that amounted to circumstantial evidence that the false proposal statement was made with an intent to deceive. Applying this test, the court explained that because K2's false statements were material, because they related directly to K2 showing how it could meet the past performance factor in the solicitation, because the false statement related directly to a solicitation requirement, the court found that was circumstantial evidence of an intent to deceive. So essentially the court started at the furthest end of the spectrum of strictness, but based on the circumstantial evidence this test it used, it kind of took the case all the way to the almost to the point of intentionality isn't required at all. So some key takeaways from Global K-9. So first of all, I think at this point, it's pretty clear that absent a new federal circuit decision on this issue, we're not going to have uniformity on the role that intent and intent to deceive play in material misrepresentation cases, especially at the court at least. That being said, if this is the test, maybe it doesn't really matter, because here the court set a pretty low bar on how you could prove intent to deceive. I think possibly the more interesting issue, and what may or may not still be resolved, is there a circumstance where a protester or awardee is actually a necessary party that needs to be joined into the case? Now, prior to this, preparing for this, I had never read Court Rule 19A, and if anybody here says they did, I would like to know why. Because it essentially involves the rule for requiring you to join necessary parties, the analog to the civil rules of procedure. Except in bid protest and in claims, there's no way to add. You can't, the rules actually don't provide a way to serve a non-government party. So, anyways. But if you look at the rule, it's actually almost a mirror image of the rule for when is somebody an interested party as a matter of right to intervene. So there's almost no difference between whether you would qualify as an interested party as a matter of right versus whether you are a party that is necessary to join. And in this case, the court did kind of look at this a little bit, but the government didn't really press the issue. And so the court concluded that because the protester was aware of through the pre-filing notice of the protest and could have intervened but chose not to, the court was not prevented from adjudicating the protest and entering exclusionary injunctive relief. But now, the thing is, the awardee hadn't actually seen these allegations until the public decision came out. There was a redacted complaint that was public, but the amended complaint, which actually had these allegations, was never public, and so the awardee never saw this. And so it begs the question whether, if you look at this rule, whether they really were an indispensable party that should have been joined. And it is interesting that the court has examined the idea of how do you join a non-government party outside of the bid protest context, and has, in fact, issued orders requiring, in a derivative case called Star International, issuing an order to join a required party. In the Scanwell Doctrine cases from back in the day, long time ago, there are actually several cases where the court did find, Second Circuit, Eastern California District Court, and Pennsylvania District Court all found that awardees were, in fact, necessary parties that had to be joined. So I think there's some possibility the motion to intervene is being brief still, and we might get a decision on this, but even if not, I think it raises some interesting questions for the future.
Thanks, Adam. So, unfortunately, I do not have any pictures of cute dogs in my PowerPoint, but do want to thank everybody in PubK for putting this together and congratulate those of you who managed to make it here despite the 2-hour school delay. So if you, like me, just pushed your kids and said, figure it out, congratulations, gold star. So we're going to turn now to the topic of revolving door hiring former government officials. And in the interest of time, I am going to skip around the slides a little bit, but there are a number of cases discussed in there that I'm not going to have a chance to touch on, but encourage you to take a look at those. There, it's not coming up. All right. So the two cases I'm going to talk about today are both started at GAO, Raytheon and CACI. And what you'll notice, and this is the standard that GAO applies in both of them, particularly in the second bullet here, is one, whether hard facts demonstrate that the government employee had access to non-public or proprietary information. And what's critical there, and you'll see in these cases, is not actually did the person access the information, but did they have the ability to access the information. The other thing is, you'll note in these cases, they talk about, well, what are hard facts? And again, not hard facts that the person actually went into the system and pulled the information, but just facts demonstrating that the person was able to get into that system. Then did the employee then leave the government and be involved in proposal preparation or guiding the contractor once they were in the private sector? And third, in light of that information and that involvement, can the protester overcome the rebuttable presumption that's associated with that? You'll see in these cases that the contracting officer's decision when he or she conducts the investigation is key. So we'll talk about some takeaway points at the end, but certainly keep in mind, if you are on the contractor side, get involved early, get involved thoroughly, and make sure that all of the information that you can provide is done at the investigation level. Don't wait until the protest arises. And if you're on the government side, make sure that investigation is thorough, well documented, and defensible, because really this is the quintessential thing that the courts and GAO look at. So turning to the CACI decision, and the site is there at the bottom of the slide. This involved an Army procurement for IT hardware. And General Dynamics Mission Systems had been the incumbent for over 20 years. The employee at issue, who is Mr. X, and Mr. X bounces around in a bunch of different cases, so welcome to our first Mr. X. Mr. X was the Source Selection Advisory Council chairperson, and also was the title that he held was, quote, operations officer. And as part of the role as the operations officer, he did participate in some analysis of GD's pricing, and that analysis was documented in email correspondence, which comes up later. So Mr. X retires from the government. After he retires and before he starts working for CACI, the Army issues a few RFIs for the upcoming procurement. He then begins consulting for CACI and starts to attend some industry meetings with the Army on this, and also attends a technical meeting where GD folks are there, and happens to mention to GD folks that he's now consulting for CACI. Obviously that raises red flags within GD. GD sends a letter of concern to the Army, and that begins an investigation into the conflict of interest issues. Subsequently, the draft RFP is issued, and 4 days later, and there's no reason to think there's any driver for the timing, but 4 days later, Mr. X resigns from CACI. And so what's important about that is that Mr. X resigns and is not part of preparing the proposal in response to the RFP, but was at CACI as in part of the RFI phase. So the CO completes the investigation, concludes that the government duties involved acquisition planning and evaluation of GD's price, that Mr. X had broad access to non-public information, and critically did so despite the fact that CACI provides a declaration from Mr. X saying that he didn't access the information, but based on email traffic and internal government information, the CO concludes to the contrary and determines that CACI is going to be disqualified from procurement. CACI files at GAO, and surprise, surprise, not to give the end of the story away, but GAO denies the protest, held that it had no basis to question the CO's determination that in fact the individual had the access to the proprietary information, and then was in turn involved in CACI's preparation of the response to the RFI. CACI then files at the Court of Federal Claims, and the case is an interesting read, so I encourage you to do it. I'm not going to go too deep into it in the interest of time, but Judge Lerner does go into detail about the court's standards and how that analysis gets conducted. A couple of things that Judge Lerner notes is, one, that the hard facts requirement does not require a smoking gun, right? So the hard fact requirement does not require something showing that Mr. X actually accessed the information, but simply facts showing that Mr. X was able to access the information. The other thing that the court looks at, and ultimately it's not dispositive in the case, but does talk a little bit about the fact that Mr. X did not have an advisory opinion. And there's some discussion about whether Mr. X needed one, whether his role was considered one of those delineated in the 2008 NDAA as requiring one of those, requiring an advisory opinion. And ultimately the court says not dispositive, but keep in mind that in that designated list, you need to look behind the actual title of the person and determine whether or not the job functions that the person was performing were akin enough to the types of job titles that would require an advisory opinion. So worth a read if you're thinking about that type of issue. So then we turn to the Raytheon case, which the facts here are strikingly similar. So in making sure that Dan has enough time for his section, I won't go too deep into them, but this involves a Navy procurement for what's called a dual brand decoy system. So again, no dogs, but certainly still interesting. Mr. X again appears. Mr. X has worked for the Navy for about 30 years. And towards the end of his career, Mr. X supports the DBD program, including reviewing a draft of what ultimately gets incorporated into the proposal or into the solicitation as a goals document. He makes recommendations about the testing procedures, practices, and requirements that should be included in that document. And the record does show that he has pretty unfettered access to a share site that has a bunch of source selection specific information in it. So the Navy proceeds to conduct the procurement and decides to do it in 2 phases. And in May of 2019, the Navy awards the first phase to both BAE and Raytheon. Subsequent, Mr. X, after this award, stays involved in the procurement from the technical side. And then about 6 months later, he starts to contact Raytheon about possible employment. He gives notice and seeks to leave the government with his immediate retirement, and does ask for a post-government employment advice opinion. But notably, when he does that, he doesn't tell the government that he was involved in the DBD program. Ends his government service and begins his work with Raytheon. The Navy subsequently issues the RFI. Mr. X is involved in the response to the RFI, again starts to attend pre-solicitation conferences, and then resigns before the RFP is issued and before proposals are due. The contracting officer looks at this and disqualifies Raytheon. The contracting officer determines that X's actions created an appearance of impropriety, noted that he didn't recuse himself when there were discussions about preparing the RFI response. He didn't disclose his DBD involvement when asking for his post-employment opinion, and he was not walled off by Raytheon from any of these discussions. Surprise, surprise, Raytheon goes through GAO, otherwise we wouldn't be here, and GAO again denies the protest. GAO adopts the contracting officer's rationale for disqualifying Raytheon, and says that the evidence showed that X was involved in the program as a government employee. He had access to non-public information. There were hard facts, including an email showing that he had access to these shared sites, and also questions his credibility similarly to the contracting officer. That case is pending at the Court of Federal Claims. However, the pleadings are sealed and many of them are classified, so double sealed. So I cannot tell you at all what's going on other than that it's briefed and it's before Judge Solemson, and I think we will get a decision at some point. I then go through in the slides, and I'm going to skip through them now, but there's a number of other cases that were issued last year on the revolving door issues, so you'll see those in your material. So there's Eastern Shipbuilding, Skyward, Guidehouse. And I'm going to pause briefly on this slide. These are 2 additional cases that are not in your materials. They were decided, or the decisions became public after the slide deck was prepared. So I just put those there in case anybody wants to write down the, or make note of the sites. I'll give you a sec to do that. All right, so what are the takeaways? Well, the takeaways here are that the contracting officer's decision is key, right? So make sure, like I said earlier, you are involved thoroughly, often, and you provide as much information and accurate information as you possibly can. If you are on the contractor side looking to hire a former government official, vet that former government official's involvement in any procurement before you onboard them, right? So let's think about exactly what did they do, and then make sure that everything they did was disclosed when they sought their post-employment advisory opinion. Because like Mr. X, he didn't disclose his involvement in the procurement, and that ended up being fatal to their participation in the procurement. Another thing you'll note is both Mr. X's were no longer employed by their respective employers at the time that the investigation was ongoing. So it seems from the cases that the employers were able to communicate and get declarations from Mr. X despite that fact, but worthy of keeping close records of what the person is doing and what they are working on, because if they do leave and they're not accessible to you, you want to make sure to have those records inside. Consider the pros and cons of seeking agency input before you involve the person in proposal drafting, right? There can be this back and forth. Obviously, we can all think of the pros and cons of that, but think critically about that before you prepare a proposal and then end up being disqualified on the back end. And then from the government perspective, or from a contractor affirmatively raising it, one thing I didn't talk about, but both of these cases involved an allegation of whether the investigation was unduly delayed. So did it take too long? Did the government sit on information for too long? So make sure you're raising the information as expeditiously as possible. And then from the government standpoint, make sure that you are conducting an investigation and that investigation keeps moving. So in both of these cases, the GAO found that there was no undue delay and that the contracting officer had been diligent in performing the investigation as soon as he or she became aware of it, but worthy to keep in mind. And then also from the government perspective, make sure to document your investigations and your decisions. Because again, that contracting officer's decision is key. The deference to it is great, but if you can't defend it and you can't support it, then it's not going to be upheld. Great. Thanks. I think I gave you enough time.
I don't know who that guy is. All right, I'm Dan Graham. I run the government contracts practice at McDermott, Will & Emery with my partner Tara Ward, and I'm going to talk about key personnel unavailability. Let's see. Okay, so just to situate this on the procurement life cycle here, whether a proposed key personnel is available at the time of proposal submission, that's a question of material misrepresentation. See Adam's slides. What I'm going to talk about is what happens when the key person is available when the proposal is submitted, but becomes unavailable prior to award. This is an issue where last year in the Golden IT case, we noted that there was an emerging split between the court and GAO. Well, now it's a full-on split. There are two judges and likely more who are explicitly saying that GAO's approach to this situation is wrong. If we can bring the slide back up. All right, so in Golden IT, which was in 2022, that was a Judge Solemson decision. He acknowledged that offerors have a good faith duty to ascertain the availability of their proposed key personnel, and they have to have a reasonable basis to expect that they're going to be able to perform. But at GAO, what happens when a key person becomes unavailable, GAO treats that as a change in the offeror's technical approach and imposes a duty on the offeror to notify the agency that they're no longer going to execute in accordance with their proposed technical approach. That then creates a real dilemma for the agency. The agency has one of two choices. It can either deem the offeror technically unacceptable because they have not met a mandatory key personnel requirement in the solicitation, or it can give that offeror an opportunity to revise its proposal, substitute a new person in that key person slot. But if it does that, well, that's discussions. It has to then give every offeror who's in the competitive range an opportunity to address any undisclosed significant weaknesses in their proposal or otherwise revise any aspect of their proposal that they want to. And all of this is driven by delays in the procurement life cycle, right? The longer it takes agencies to award contracts after the release of an RFP, the longer that offerors have to maintain the availability of individuals that they've identified as named key personnel. And that's particularly challenging for non-incumbents. The incumbent, in many instances, is just proposing the key personnel that it currently has in place on the contract. Non-incumbents are often hiring people into that spot on a contingent basis where they won't become employees until and unless the contract is awarded, which in some cases can take over a year, sometimes up to 2 years. And then the delays in the procurement cycle further exacerbate the burden on the agency if an offeror has to come forward and say, you know what, my key person in this slot is not available. Now the agency, who's already taken longer than they would have liked to get this contract awarded, has to decide, am I going to reopen this up to another round of proposal revisions to address this one offeror's problem? In Golden IT, Judge Solemson said, GAO's rule requiring notice that a key person is unavailable is just not grounded anywhere in the FAR or procurement law, and it's unfair. So fast forward to last year, and we have the KPMG case. What's interesting about the KPMG case is the procedural posture in which this case came to the court. In KPMG, GAO had sustained a protest challenging an award to KPMG on the basis that one of KPMG's proposed key personnel was no longer available. GAO sustained the protest, agency took corrective action, reevaluated KPMG's proposal, decided that KPMG was technically unacceptable, awarded to another offeror. KPMG then protests at the Court of Federal Claims and put squarely at issue whether the agency's action was unreasonable because GAO's rule driving that sustain was unreasonable. And Judge Lauren Smith, Senior Judge Lauren Smith, said, yes, it was, GAO's rule is unreasonable. So the facts are a little convoluted, but they're important. This is still, I think it's a clear split, but there is opportunity to distinguish KPMG from other cases down the road, so I'll summarize the facts. The proposed key person in KPMG was actually a subcontractor employee. KPMG was the incumbent. The subcontractor was a subcontractor on the incumbent contract, and the key person was a key person on the incumbent contract. Signed a letter of intent allowing the subcontractor and KPMG to use his name in their proposal. Also signed a letter of intent allowing another offeror to use his name in their proposal. Nothing, that's an issue of private employment law between the different employers, not something that GAO is going to enforce, and something that happens quite frequently. Both offerors, I think from GAO's perspective, both offerors had a reasonable good faith basis to believe that this person was going to perform as intended because he signed a letter of intent. He was working in the position that he was proposed for at the time of proposal submission for KPMG's subcontractor. He was working in that position at the time of award. What triggers the protest is prior to award, he announces his intention to resign. He announces his resignation. That then triggers a series of communications where KPMG's subcontractor is trying to persuade him to stay. When you read GAO's opinion, it's a little bit like that scene out of Dumb and Dumber where the subcontractor might think, well, you're telling me there's a chance, but no, he's saying, I'm leaving.
from GAO's perspective, that's all that matters, right? He does leave after contract award. Another offeror, Selke, finds out about that, challenges, knows that he's in the position he's in on the current contract, and challenges KPMG's proposal as under GAO's longstanding rule. The record's developed. GAO sees that this guy did formally announce his resignation, wasn't terribly concerned about KPMG's or the subcontractor's efforts to persuade him to stay, wasn't moved by the fact that he was still an employee as of the time of award, sustained the protest. The agency did exactly what GAO said to do in its recommendation. It went back, it reevaluated key personnel. It did not permit proposal revisions. It did not permit KPMG an opportunity to replace that person. And so it deemed KPMG technically unacceptable and awarded not to the protester at GAO, Selke, but to another offeror, Deloitte. KPMG goes to the court and puts squarely at issue, citing Golden IT, but puts squarely at issue GAO's rule and argues that the agency in this case acted arbitrarily and capriciously because the GAO rule that the agency was implementing was itself arbitrary, capricious, not in accordance with the law. KPMG, the court in KPMG, again, Judge Lauren Smith, adopted Golden IT's test, determined that all that was required was a reasonable belief at the time of proposal submission that the key person would deploy in the position for which he was proposed. And then specifically stated, an offeror is not obligated to notify an agency of the departure of key personnel post-proposal submission, absent an affirmative requirement to do so in the solicitation. So what's the takeaway here? We're going to see more protests at the court. We're going to see more protests that follow sustains from GAO, applying GAO's long-standing rule in an effort to get the court to continue to say, no, that's wrong, and get more judges. This was not appealed, so we're not going to see the Federal Circuit intervene just yet, but eventually we will. We know that GAO in the past has aligned its cases with decisions of the Federal Circuit, most notably after on OCIs after Turner Construction. It's an open question whether GAO is going to wait for a Federal Circuit decision to try to align itself with the Court of Federal Claims' law, but stay tuned. This will probably be an issue we'll be talking about at next year's year in review or the year after. Quickly, two other cases that are irrelevant here. Strativia involves non-competes, and it's kind of the opposite. So GAO will not hear an argument that a key person is unavailable simply because they signed a non-compete with the incumbent that they wouldn't go work for a competitor. GAO has no authority to decide the enforceability of a non-compete. As most of us know, non-competes are subject to state law and very complicated rules that vary from state to state, and they're also subject to a FTC rulemaking that would outlaw them in large part. But saying somebody has a non-compete with you is not a way to say that they are unavailable to a competitor. And then Global Alliant, this is an agency trying to use the key personnel unavailability argument as a defensive measure against the protester. GAO essentially applies the same rule. As long as the person was available at the time of award, the fact that the person has become available post-award during the pendency of the protest does not make the protester no longer an interested party. 10 seconds on the statistics, nothing to see here, right? The numbers are starkly different, but the change is due entirely to the CIO SB4 protest. There were hundreds of them. They were sustained, resulting in hundreds of sustains. That's music. And,
Okay, everybody, thanks for listening to our presentation. I think we have some questions. Dan, it looks like the first one is on first one tied to your presentation. No.
No, we're talking about the Aetna decision on impaired objectivity OCIs and firewall. I don't think the rule's quite as bright as that, the virtually irrelevant line, but it's still a tough lift. So shall I move on to Doug Kornreich's question, which does go to my slides? So Doug, it does call for clairvoyance. I think agencies do have a lot of power here. Agencies can specify in the solicitation whether offerors must advise the agency of the unavailability of key personnel between proposal submission and award, or the agency can specifically say that offerors don't need to notify the agency of the unavailability of key personnel prior to award. And if the agency does that, then I think both GAO and the court will respect that. I think both the Golden IT case and the KPMG case, when they say that there's no duty to notify the agency of the unavailability of key personnel after proposal submission, they qualify it by saying unless the solicitation provides otherwise. So the agencies are in the driver's seat here. They can craft the rule, and both GAO and the court will follow it. The issue is what happens if the solicitation is silent. Then I think for the time being, GAO will say there is a duty. The court will say there isn't, and it will take a few more decisions out of the court and potentially a decision by the Federal Circuit before we see a reconciliation between those two fora. Oh, I'm sorry, we're not repeating. I assume the questions were available to everyone in the forum. The question that I just answered was, would agencies be justified in following Golden IT in ignoring a GAO recommendation? And my answer is yes, if they're willing to go the distance, withstand a sustain at GAO, and then go to the court. But the simpler approach would be to state clearly in the solicitation what obligations offerors have to notify the agency of the unavailability of key personnel.
So the next question we have is what's our outlook on whether there's more of a move to protest at the court? Maybe. I mean, my personal view on that is I'm probably have traditionally been more willing to go to court with my initial protest than most people I know will, but I think there's certainly been more people who are shifting to going straight to court. In part, I think also because the cost efficiencies that we used to see at GAO just aren't necessarily there anymore compared to the court as well. And also, I think the shift, seems like every year we're talking about more and more substantive differences in case law between the court and the GAO. And almost universally, the court decisions are more protester friendly when there is a divergence. So I think that it is certainly, I can't say it's very hard to show statistically that's happening because the sample size at the court is so small compared to the sample size at the GAO, but I think anecdotally it is happening and it will continue to happen. Don, or Dan, do you have any thoughts on that?
Yeah, I'll chime in. I do think there's been an uptick in court protests, and in part, some of the reasons you mentioned, Adam, and also because of the new judges. And so the cases are moving more quickly at the court than they had been for many years. I can say when I first came out of DOJ, I challenged the private bar to say, well, why wouldn't we go to the court? It was just sort of ingrained that you'd want the perhaps an objective, more objective view of somebody new to the case rather than being for an agency. And quickly changed that tone and started going to GAO. And I think the pendulum is swinging a bit and going back towards a mix of the two. I will say, was actually talking to some folks recently who said that one reason they think that folks are willing to go to the court is that the government has been recently more willing to take to implement the voluntary stay. And so that does lead to the cost efficiencies, Adam, that you're talking about. And there have been some discussions as to whether that should continue. So so long as that is happening, the cost efficiencies certainly work out. To the extent you need to do the TROPI, it can perhaps swing back towards GAO.
I agree with all those points. For me, though, the biggest and the most frequent reason to go to the court is limitations on the scope of the record at GAO. And what I personally think has become a fairly arbitrary dismissal practice at GAO. This line between speculation and evidence is very elusive for GAO protests. At the court, you can plead on information and belief, and you get the full record. You don't waste time trying to overstate how much you actually know, particularly in a competitive procurement where it's generally illegal to know much about the other side's proposal. So the court is becoming a forum where if you're using the protest process to just make sure you got a fair shake, that your proposal was evaluated fairly, even-handedly, and in accordance with the requirements of the solicitation, you can just file the protest and get the record. And as Dawn pointed out, you're not going to fight about the scope of the record at the court. And as Dawn pointed out, it's easier now to get the stay, a voluntary stay that you would have gotten automatically at GAO. It's easier to get that.
I'll add one more thing on that. I mean, I think like another trend that's helped like pushing things in my view to court a little bit is that I'm seeing more early corrective actions at the court than there used to be. Like I'm seeing the agency actually look at the record early, which didn't always happen there, which was kind of an advantage of the GAO. You might spend less time getting to a corrective action. And also the DOJ, I think, is affirmatively working to try to provide early information if you didn't get a real debriefing, to see if let you evaluate your protest a little bit better and see if whether it's worth carrying forward. So I think those are all things that make the court a very attractive place for protesters from both a winning, but more just an efficiency standpoint than anything else.
I do think, just one more, Adam, before we move on, that extended debriefing process has impacted that decision too, because companies are getting more insight into at least their own evaluation before you file the protest, which then certainly informs, I think, a decision more than perhaps in previously as to where you would go.
Don, you want to take the next one?
Sure. I'll read it. I think there was a request to read them. It says, what best practices, takeaways would you offer to agency ethics and procurement counselors advising departing employees to protect the integrity of procurements based on your understanding of the case law? Look, I think certainly as the cases show, it really is a case-by-case basis as to what that individual worked on and what they knew. To the extent that you can encourage or get an employee an ethics opinion before they leave, and make sure that that is that's informed by accurate facts of the scope of their work, then that's going to be the best way to inform both them when they leave and the agency when they're involved with a company that subsequently bids on something. The other thing to consider is when a person does leave and you know they are with a company and the company is bidding on stuff, what is the relationship, if any, between the folks that are on the source selection board or the source selection authority and that individual? So was it somebody that individual worked closely with, reported to? One of the cases suggested that that's not an issue, but certainly a way, if you're within the agency, to be thinking about how to draw, further distance between the procurement and the individual who left. But, but biggest thing, sit down with them, understand exactly what they worked on, understand the scope, and understand where they're going, and then that will help as things progress into the procurements that are perhaps follow-ons to the things that they had been working on.
Yeah, I completely agree with that. I think it's a garbage in, garbage out process, right? If the departing employee isn't providing a very robust, fulsome disclosure of everything they worked on, and the designated agency ethics official is just sending a template letter that just says, here's what 18 U.S.C. 207 says, here's what 18 U.S.C. 208 says, here's what the Procurement Integrity Act says. That's meaningless and really doesn't do anything to protect the integrity of the procurement process or actually implement the ethics laws. The other thing that I think tends to get missed a lot is that DAOs, the designated agency ethics officials, are not responsible for determining whether there might be an unfair competitive advantage based on something that exists in somebody's head, right? That the ethics laws and the Procurement Integrity Act, post-employment restrictions that DAOs enforce or advise on are very specific and bright line rules. And so even if the DAO does his or her job to the best of his or her ability with perfect information, the contracting officer still has to be in the loop, and the contracting officer still has to make some reasoned determination that there isn't some threat to the integrity of the procurement process based on information, access to information that the departing employee had. That really isn't a situation that is regularly captured in the departure ethics process.
Agree 100%.
Well, I think that's all the questions we have. So thank you everybody for attending, and we'll turn it back over to the PubK team. And thanks to PubK for having us.
Thanks, everyone.
Thanks all.
Thank you for joining us today. And thank you to our panelists for their presentations and live Q&A. And again, special thanks to our sponsors whose support made this event possible.